traded in. Some new stranger dwells within. Crazy circles are leading me back where I've been. So I'll start over again. Give until you give in. Pay the devil now to make amends, and I'll give all this back to you in the end.
For several years, I have said that the judicial officers, in Walker County, Alabama, have criminal and coercive intent in the way they handle their failure to appear and criminal contempt cases. The recent in-custody death, in the Walker County Jail, of Mr. Brian Michael Freeman, is one of many examples of the adverse effects of the local administration of justice. Additionally, I strongly suspect that the aftermath of Mr. Freeman's death played a role in the arrest of the Walker County activist and manager of 3 radio stations, Terry Keith Hammond, who was the first to inform the public of a possible hanging death in the Walker County Jail. With or without the connection to the aftermath of Mr. Freeman's death, Mr. Hammond's arrest is a prime example of the deceitful and retaliatory nature of those involved in the administration of rights and justice, in Walker County, Alabama. Furthermore, my activism and the retaliatory action of Walker County officials creates evidence of the malicious aforethought with deliberate indifference to the liberty interests and other basic and fundamental rights of each individual defendant, in the manner and means in which rights and justice is administered, in Walker County, Alabama. This is especially true, in terms of, 1. Establishing the specific intent of the judicial officers in the issuance of Mr. Freeman's 2 failure to appear warrants, 2. Establishing the specific intent of the judicial officers in administering the local procedures which were inflicted upon Mr. Freeman immediately following the execution of the 2 failure to appear warrants for Mr. Freeman's arrest. To be clear, on multiple occasions, I have complained about the very procedures that were foisted upon Mr. Freeman and a multitude of unwary souls, both the guilty and the innocent, alike. These rogue lunatics and thin-skinned psychopaths, who are invested with the judicial powers of the great state of Alabama, know, beyond a shadow of a doubt, that these local procedures violate the very concept of due process of law. And yet, not only do they continue these rogue patterns and practices, but they also go to extremes to defend their rights to commit these. Alabama law enforcement agency has saying that on April 23, 2018, Brian Michael Freeman was arrested by the Jasper Police Department on 2 failure to appear warrants, then booked into the Walker County Jail, and died on May 1, 2018. Law enforcement claimed to be withholding the cause of death until the results of a medical examination. However, prior to official statements being released, local activists were reporting an overnight hanging but were withholding the name until all of the family were notified. The trial court records state that both of the 2 failure to appear warrants were electronically signed and electronically issued by Walker County Circuit Judge Doug Ferris, because Mr. Freeman failed to appear on February 5, 2018 for 2 separate jury trials on 2 unrelated criminal cases. These 2 unrelated criminal cases occurred several months apart, and no reasonable person would expect these 2 unrelated cases would be tried together. It shocks the conscious to think the one person would be required to defend themselves in 2 different jury trials on the same day. Suspiciously, there is nothing on the case action summary to indicate that any of the witnesses were subpoenaed to appear for the jury trial on February 5 or at any other time during the month of February. More importantly, in Walker County, Alabama, there are only 13 so-called jury weeks a year, and as a matter of general pattern and practice, once a month, each of the 3 Walker County Circuit judges are scheduled a large number of cases to appear before the judge in one day. The court calendars refer to these days as a civil, criminal jury trial docket call. These jury trial docket calls are always labeled as a first call on the case action summary of each case that is placed on the jury trial docket call, and no matter how many times a case is placed on one of these large jury trial docket calls, the label on the case action summary is always a first call. In substance, these so-called first calls can be construed as nothing more than a trial readiness conference, in which there is no guarantees a case will go to trial during the next so-called scheduled jury week. Arbitrarily and capriciously, and without knowing with any degree of certainty about which case will be allowed to go to trial, when a case is placed on one of the 3 large jury trial docket calls, there is also a jury trial scheduled for the case during the so-called jury week for that particular month. It does not seem possible for these 3 judges to conduct all the jury trials that are scheduled to go to trial on the days they are scheduled, and it does appear that it is expected for a large portion to be continued. However, these cases are still arbitrarily scheduled a jury trial each time a first call is scheduled. Given the totality of circumstances surrounding the 2 arbitrarily scheduled jury trials, it is extremely likely that Mr. Brian Michael Freeman believed, possibly even told, that his 2 cases were not going to be given to a jury on February the 5th of 2018 as scheduled. There has been multiple searches purchased for Mr. Freeman's name from Just One Look, Alabama's on-demand access to trial court records. The only criminal case from 2018 for Mr. Freeman is a Walker County Circuit Court case, where Mr. Freeman was indicted on April 30, 2018, for an incident which occurred way back on October 12, 2013, meaning, he was not charged with the crime of bail jumping, as any reasonable person would expect to happen to anyone who is foolish enough to fail to appear for a jury trial in the great state of Alabama. The case action summary of the official court records claim that both of the 2 failure to appear warrants were returned to and housed at the Walker County Circuit Clerk's office on April 23, 2018 at 6:50 a.m. The sworn certificate of execution for the 2 failure to appear warrants clearly state that Amber Elaine Kilgore, of the Walker County Sheriff's Office and not the Jasper Police Department, executed the 2 failure to appear warrants on April 23, of 2018 at 6:50 a.m. In all criminal prosecutions, the Constitution of Alabama protects a right to bail. This has repeatedly been held to provide an absolute right to a lawful order of bail, not to release. Even after repeated failures to appear, an accused person still has an absolute right to a lawful order of bail. Once an order of bail is entered into the trial court record, then the order of bail can be challenged under the state and federal constitutional prohibition against excessive bail. There was no order of bail attached to the 2 failure to appear warrants. There are no bond revocation complaints or modification petitions, as required by Rule 7.5 of the Alabama Rules of Criminal Procedures, for the court to be able to revoke a bail bond or modify the conditions of a bail bond. There is no indication on the case action summary of a due process hearing, of any kind, occurring within 72 hours of Mr. Freeman's arrest pursuant to the 2 failure to appear warrants. If the court fails to perform the court's duty of holding a due process hearing within 72 hours of arrest for a bond revocation or bail modification proceedings, then Rule 7.5 of Alabama's Rules of Criminal Procedures grants an accused person an absolute right to the reinstatement of. There is no indication on the case action summary suggesting that Mr. Brian Michael Freeman was found guilty of criminal contempt for his one act of failing to appear before the Walker County Circuit Judge, Doug Ferris, on February 5 of 2018 at 9 a.m. The maximum authorized term of imprisonment for one completed act of criminal contempt is 5 days. Mr. Freeman was incarcerated for about 8 days. However, my faith and trust in the Jasper Police Department demands that I actively look for evidence that the city of Jasper, Alabama, did not hold Mr. Freeman in its municipal jail for a day or 2, just for investigative purposes. Of course, the original bail. The Supreme Court of the United States of America has stated that when a court incarcerates a person for civil contempt of court, due process of law requires the trial court to know, prior to ordering the incarceration, that the alleged contemptor has the ability to perform the act that the court has previously ordered the contemptor to perform, and the alleged contemptor has continuously refused to perform the act, thus giving the alleged contemptor the keys to his own prison, to gain an immediate release, upon performing the previously ordered act. If the contemptor has lost the ability to perform the previously ordered act, then due process of law forbids the incarceration of a contemptor on the civil contempt theorem. Though criminal contempt is still a viable option for punishing the completed act of losing the ability to perform the previously ordered act, there is no indication in the trial court records, suggesting that the bondsman was sent a notification of a pending hearing, or jury trial, having been set, nor is there any indication of an attempt to proceed with the civil forfeiture of the bond that the bondsman posted to gain Mr. Freeman's release pending a jury trial. It appears that Walker County Circuit Judge, Doug Ferris, was holding Mr. Brian Michael Freeman until the so-called next available jury trial docket call, on May 30, 2018, where Mr. Brian Michael Freeman may or may not have been granted a jury trial in the near future, given the fact that the Walker County District Attorney's Office only got around to producing an indictment for Mr. Freeman's 2013 possession charge. After Mr. Freeman's most recent arrest, it becomes clear that the Walker County District Attorney's Office did not have any intent to strike a jury in any of the 3 pending cases against Mr. Freeman. This indictment alleges that Mr. Freeman was in unlawful possession of a controlled substance, back during a time when the lead investigator for the Drug Division of the Walker County Sheriff's Office, Sergeant Ralph B. Williams, was allowing his team to make arrests, then hold the arrestees for weeks, if not months, on end, before court records were created for the arrests or obtaining the constitutionally required, prompt judicial determination of probable cause. There is no indication on the case action summary showing where Mr. Freeman's court-appointed attorney, Stephen Travis Wilson, made any attempt to gain Mr. Freeman's release.